Okay, we're at 3 minutes past 3 SAT, and we are dealing with today's procurement session, purchasing, negotiating services and products. Sat Hardwood from L'Esperance Mendez is here today to walk us through this. Loads of time for questions. We've got a few great scenarios to kind of walk through from the simplest of things that we get done to the more complicated, and talk through the procurement process as we go through. Just a little reminder to everyone that this session is archived. It is recorded. So if you do have any questions, please put them in the Q&A. I'll monitor them closely as we go along. We'll try and get to them, or at least bundle them together by topic as we go through. Don't put any personal information in as we go through. Our sponsor today is TELUS. So many thanks to TELUS for this week's sponsorship. And it helps to ensure these sessions are at no charge and that they get archived on the YouTube website, enabling them for everyone. Again, privacy, just two things to remember under this screen. First off, no personal information with respects to anything that you may put in the Q&A. But the other thing to remember is that any questions you ask, any advice or information received, this does not constitute legal advice. There is no way, given the limited amount of information that anyone would have, to be able to give you any kind of competent advice on this. But the speakers are always very happy to talk to people or communicate with them afterwards if you have any questions. So Sat, thanks so much for joining us, and all over to you.
Great. Thank you very much, Tony, and thanks for having me, everybody. As Tony said, my name is Sat Harwood. I'm a lawyer with L'Esperance Mendez. Been working with Strata Corporations for about 14 years now. So happy to come and join you today from my beautiful and sunny home in North Vancouver, as you can see from the background. Just before we get going, hopefully the connections will be good today, despite the weather out there. I should also mention too, I'm also house sitting my dog right now. So if you hear any barking in the background, please excuse her. She is quite lovely despite the neurosis. So with that being said, let's jump right into this topic for today. And as you can see from the first slide, we raised the point, Houston, we have a problem. I start with that because I think it's important before we get into the topic of procurement to address how do we get there. And typically when you look at the procurement area of strata governance, it always arises because there's the discovery of a problem. How does that happen? The obvious one, you've got a catastrophic failure like a pipe burst, sprinkler system malfunctions, etc. You've got what I'll call unexpected occurrences, fires, floods, accidents. Some of you may recall many years ago, we had an incident where a small plane actually crashed into a strata in Richmond. So not something we would typically think of as something within the realm of strata risk, but it can materialize. Owner complaints are another really common one. There's a leak coming in through my ceiling. I don't know what's causing it. Asset management investigations. This is sort of a broader category, typically leads to the discovery of more substantial problems. How do we get there? You've got depreciation reports, warranty reports, condition assessment reports. And of course, whenever you get those reports, whenever you get those complaints, the first thing that council has to look at is how do we proceed here? How do we deal with this situation, and what are the solutions going forward? Another point I want to make before we get into procurement more generally, we need to understand where the obligation to repair and maintain comes from. The Strata Property Act is pretty clear on this. It says that the Strata Corporation is responsible for managing and maintaining the common property and common assets of the Strata Corporation, and that management is there to benefit all of the owners. This flows from Section 3 of the Strata Property Act, right? So Section 1 is your definitions. Section 2 is here's what a strata corporation is. And the very next one after that is you have to manage these assets. So Section 3 speaks to it. Section 72 sub 1 also reinforces that obligation, sets out the strata's duty to repair and maintain common property and common assets. And then 72 sub 3 also makes clear that the strata corporation's obligations will also extend to strata lot property as set out in the bylaws, and many strata corporations bylaws will address components of strata lot property that are a strata corporation responsibility to repair and maintain. construction pricing. This is an important one whenever you get into procurement, right? I mean, the end of the day, it's very clear we have an obligation to repair and maintain the building, to maintain those assets for the benefit of all owners. But in the end of the day, none of us want to pay too much. None of us want to feel like we got ripped off. We've all got our own financial constraints that we deal with, and certainly in a real estate market like British Columbia's is, and in Vancouver in particular, very, very pricey. So how do we control those variables? Key factors that we look at: contractor availability. This is an important one, right? The reality is, if you are in a busy construction market, a busy remediation market, renovation market, etc., it's going to be harder to find people to do the job, and they're going to charge you more, right? Anybody who has gone out there recently and tried to get somebody in to paint their strata lot, redo their flooring, etc., will know that it's hard to find people to do the work. They're not always the most reliable, and there's often significant waits, right? So contractor availability is critical. Risks of construction, this is a really important variable. The simple reality is, if you have a high risk project as opposed to a low risk project, it's going to cost you more. And it's going to cost you more because the contractor doesn't want to underprice the job and find out that they walk away losing money. So the risks of construction, as I said, they're really critical in all of this. Geography is another important one. The simple reality is there's going to be more contractors available in a larger real estate market like Vancouver than there is going to be in a smaller real estate market like Radium Hot Springs. Seasonal pricing is an important one. Weather conditions and construction feasibility are particularly important. In Vancouver, it's mostly focusing on rainy conditions, these sorts of things. Same would go for Vancouver Island. Once you start getting into the interior, further away from the coast, it's snow. And the reality is there is simply certain seasons of the year, certain months of the year, when many projects simply cannot happen because the ground is too hard, the conditions are too harsh to undertake those repairs in a prudent manner. Timing is a really important one. The reality is, if you go to the market earlier than later, you give that contractor more time to fit that job into their schedule, you're likely to get a better price. You're likely to have more contractors available, right? If you're trying to get a job done in the summer of 2022 and it's May and you're just starting the process of reaching out to contractors, they're probably busy, right? They're going to be busy. They may not have the availability to do the work. And the ones that are available, you have to kind of question why they're not busier, right? So timing is important. Competition amongst contractors is also important. And then, of course, supply and demand is a critical one. And for anybody who has been involved in construction and remediation projects recently, you'll know that there's been significant inflationary pressures when it comes to both materials and labor in British Columbia. Deciding how to proceed. This is a really important one. There are two sort of conceptual frameworks that we approach repair projects, remediation projects from. One is a more informal process where you simply solicit quotes, and the other is a much more formal process where you actually go through a tendering structure. And I'm going to get to tendering in a bit more detail later on, but a couple of sort of basic points here. With a request for quotes, obviously it's simpler. You're going to be a lot quicker to get to market, much easier to get people's attention. You may not get the lowest price, right? You just simply don't know whether you're getting the lowest price because who knows? There isn't a more structured competition process. With a formal tender process, you may get a lower price, but it comes with some strings attached, right? One is that it's more complicated. It's not a process that you're going to want to run on your own. There are a lot of different pitfalls, which we'll talk about later. And of course, there is a greater risk of being sued by parties who lose out on that bidding process. So potential for better pricing, certainly very important when you're looking at really large projects like envelope remediation projects or piping replacement projects, these sorts of things. So definitely worthwhile looking at, but there are some risks that we'll talk about later. Want to talk a little bit about some of the contracting basics here. We make the point in this slide that when a contractor or consultant is engaged to provide work or services, whether verbally or in writing, a contract of some form is typically going to be found to exist. That contract is going to bind the parties to either specific work, to a general scope of work, or to a discretionary scope of work. Now, what do we mean by specific, general, and discretionary? The best way to sort of talk about this is really through an example. So let's say you have a fencing replacement project. A specific scope of work might say something like, the contractor is being hired to replace the fencing that runs from point A to point B. So a very specific section of the fencing. A more general scope of work, the contractor is being hired to replace the fencing within the property itself. Doesn't get into details about how much fencing, et cetera, but it exists within the framework of the property. Discretionary scope of work. The contractor is being hired to replace those sections of the fencing which are deemed to be rotten. Well, again, there's an element of discretion there. How much rot is sufficient to trigger that obligation to repair, and how much of it can be saved. Depending on the level of specificity versus general and discretionary language you have within a contract, it can make a big difference between having cost and price certainty versus a much more open-ended pricing structure that could lead you to a bill that is larger than you were initially anticipating. So we make the point at the next bullet here, which is that a written contract is always recommended for contracts in respect of goods or services. And we say that because, as I said a few moments earlier, you can have a contract that is formed through written documentation or through oral communication. Now, with oral communication, there's lots of court decisions that have found binding agreements, notwithstanding the fact that everything was said in writing, by a phone, I should say. But the challenge that you face with an oral contract is you get into a he said situation, right? So a dispute arises, contractor says, I was expecting to to be able to charge X. The owner says, no, it was Y. The court's going to have to sort that out and try to come to a finding as to the truth of what actually happened. And the outcome of that dispute may be that you as a strata corporation win. It may be that you lose, right? So having a written contract is a way to mitigate that risk, to ensure that there is less avenues for disagreement, less need to call in lawyers, and less chance that you're going to come out of the end of this process finding out that you paid a lot more than you bargained for, or you got a lot less than you bargained for. And at the end there, we make the point that written agreements, they help to protect stratas and to ensure there is a clear understanding of each party's rights and responsibilities. So that ties back to what I was just saying. If you don't have it in writing, court's going to have to try to parse it together by people's oral testimony in court. They may need to look at emails, other sorts of communications to try to unpack it. There's an enormous amount of uncertainty when you get into oral contracts. So having things in writing is always the first step to protecting your rights going forward. Now, in terms of protecting our liabilities, I'm just going to bear with me here. I'm sliding forward to have a couple of notes that I wanted to address on that. When you look at a contract, you want to bear in mind that no contract is too small for a written agreement. It's a starting point to a lot of these disputes. And I say that really from experience. I mean, sometimes as legal counsel, we get brought in to help resolve, contract disputes that run into the hundreds of thousands or millions of dollars. Other times we get brought in because the dispute is over $2,000 or $4,000, right? Why do we get called in on those? Well, typically what happens, work is done, there's a misunderstanding about what was required. The contractor insists on payment, the strata doesn't want to pay, and so they come out and they seek legal advice, right? In a worse situation, contractors stepped in, they've filed liens against strata lots within the building, they've encumbered people's property, hindered their ability to remortgage their home or to sell the property, all these sorts of things. And there's no monetary limit on how small of a lien a contractor can file on your property. So as I said, we often get brought into disputes where the monetary value can be quite small. And it's always unfortunate there because, inevitably you get into a situation where the legal costs can very frequently outstrip the value of the dispute. So you've got a $4,000 dispute, and at the end of the day, there can be $4,000, $5,000, $6,000 worth of legal costs because the contractor has taken an aggressive approach, wants to get payment, and the strata is trying to find a way to reduce that financial burden. So in the end of the day, it's always better to get a contract in writing up front, to have that reviewed by a lawyer. The reality is it's simply going to be less expensive to deal with it at the front end than at the back end after a problem has arisen. Now, in terms of written contracts themselves, there's a couple of different types of contracts you can look to. You can have an industry contract where there is a certifying consultant overseeing the scope of work. And we give the example there of a CCDC contract. The CCDC contract is an industry standard document that is typically used on very large projects such as a building envelope remediation or a piping replacement project. They're very handy contracts to use. They're very, very detailed. They don't make a lot of sense for a $5,000 project, but they make an enormous amount of sense when you start getting into the hundreds of thousands or the millions of dollars in costs. You can have a general contract whereby the terms and conditions are negotiated between the parties, or where the contractor themselves presents the contract to the strata corporation for review and signature. You can have an email or approved quote that confirms the scope of work, deliverables, and cost. And you can have obviously an oral contract, as we talked about earlier. Now, a couple of comments on this slide before we move on. Obviously, with the CCDC contract, this is an industry standard document that has been in use for decades. It's very, very detailed and is designed ultimately to minimize problems. When you get into those contracts, though, they really are geared to companies doing business with one another. There is language in there that creates some problems from a strata governance perspective. So payment requirements, notice, compliance requirements, these sorts of things. So despite the fact that this is a very well used and generally very useful contract, the reality is there is certainly some modification that can be made to that contract to give strata corporations greater flexibility to undertake the governance tasks that they need to as part of a strata. When you're looking at general contracts that are provided by a contractor or subtrade, whoever, we need to bear in mind, especially if you're being presented with a finished document from the party you're looking to enter into a relationship with, that document was probably drafted by their lawyer or somebody in their office who likes to moonlight as a lawyer. It's probably got some language in there that is designed to benefit the contractor, to give them the upper hand in a dispute. So, you may get a contract from them that is significantly smaller and less detailed than a CCDC contract, but there's a lot of merit in reviewing those documents to ensure that that you aren't inadvertently committing to a certain contractual relation that you weren't anticipating. So taking a look at those things early is really critical. Another slide here entitled Protecting Our Liabilities. We make the point here, we ask the question, who bears the loss if a contract lacks specificity? And we note there that the strata corporation, as the client, may ultimately be left with losses or liabilities in the event of that a contractor fails to perform their scope of work and there's no written agreement defining the terms and conditions of the contract. We also make the point that the corporation's insurance provider is also potentially exposed to losses in the event that there are damages to the strata corporation, such as flooding from plumbing repairs. And that one is a really critical one, right? Because in the end of the day, if there's a problem in the project, if things go wrong and damage arises to the building, the concern there can be that there is damage to the building, and your insurance company is going to have to step in and cover that loss, right? Well, if they step in and they've spent a few $100,000, let's say fixing water damage to the building, they're going to look to be made whole as well, right? They have to legally insure you, protect against that loss. But in the end of the day, they'd like the ability to sue somebody else, right? So if you have a contract with a contractor that doesn't have indemnity language, doesn't have warranties or guarantees in respect of the quality of the work and what happens if things go wrong, it can make it a lot harder for the insurance company to recoup their losses. And of course, long term, that has an impact on your insurance rates, right? The simple reality is the more that insurance companies have to deal with claims, the more they have to pay out money, the less that the money is recouped by way of third-party claims, the higher your insurance premiums are going to be. And so that penalizes all of your owners going forward. So the next, oh, sorry.
There we are. There we are.
Thank you, Tony. This is protecting our liabilities, slide 3. We make the point here that if a strata has not entered into a written agreement and screened contractors to confirm they have liability insurance, the insurance provider is not going to be able to subrogate, as I mentioned. And in a worst case scenario, we make the point that if there's too many claims, if there's an inability to subrogate, it can over the long term actually hinder a strata's ability to even get insurance in the first place. And I can say certainly from our perspective, we've had a number of calls from strata corporations over the last year, year and a half, where they simply are uninsurable. That's a very frightening possibility for the owners, because they know that if there's ever a major insurance claim, a catastrophic problem with the building, they're no longer going to have that ability to turn to insurance, and ultimately they'll be self-insured. Owners are going to have to cover that loss. So it is really important, not just to keeping your premiums down, but also in terms of your insurability more generally. And at the end there, we make the point that failure to insist on that written contract and proof of liability insurance may hinder your ability to renew the property insurance itself.
Sat, before we go on to the next slide, I think it'd be really helpful for the participants to understand. We've had 2 such claims this year that our office has assisted strata councils with. One was caused by a contractor of the strata corporation doing mechanical plumbing work. Another was a contractor of an owner doing renovations, plumbing renovations in the units. Neither contractors were what we would consider, licensed certified people. The strata decided they would kind of find someone that was cheaper on the go. But both resulted in substantial insurance claims. And the insurance providers are really struggling to try and to recover or to subrogate. And they've already been put on notice as a result of both, in both stratas, that their insurance renewals are going to be very difficult.
Yeah, it's a significant issue. And the other thing I just add to that as well, Tony, we've dealt with a few clients this year, both stratas as well as homeowners, where the issue that they have faced is they're dealing with a substantial insurance claim with their property insurer or their condominium insurer. And that those claims, particularly when you're dealing with things like fire losses or floods, they can take quite a long time to resolve. Mid-cycle, like in the middle of the claims process, the insurance policy comes up for renewal, and the insurance company says, you know what, sorry, we're not going to renew your insurance this year, right? And unfortunately, there's nothing within the Insurance Act that requires them to renew that insurance. So, again, it's a very challenging situation to be dealing not only with an insurance loss and the disruption to your home and your life, but then being told, and by the way, we're actually not going to insure you going forward, even while this claim is being processed. So, Quite a frightening situation.
Yeah, no, it's terrifying. And it's terrifying for all of the rest of the owners in the building. It just goes back to, we'll refer everybody back to the session on bylaws, having a toolbox of bylaws that work, because the standard bylaw of alterations with respect to strata law under the Act is terribly insufficient. And it really needs to be a bylaw that requires approval, descriptions, insurance, disclosure, all of these structures within the relationship to ensure that all the rest of the owners aren't paying the price for this.
Yeah, absolutely. Anyway, so let's move on to the next slide. We titled this one "Get Your Contract in Writing," and it's a message, obviously, that we have been repeating multiple times today. We make the point that signed quotes or oral agreements can still be contracts, but in the end of the day, they're not good contracts, right? And just because a contractor has said, we'll do X, Y, and Z for $15,000, that isn't necessarily going to be enough to protect you in the event of a problem. So we make the point here that contracts need to address numerous issues, such as what work is being done, how much will the parties be paid, how do you deal with unexpected conditions, what happens if something goes wrong, and of course, will you have the benefit of the warranty? Now, couple of examples I'd like to digress to here. The scope of work is really critical, right? Is it general or is it more specific? And I return back to that example I gave at the beginning of the discussion about the fence replacement project. Payment is another critical clause in a contract. Is this a fixed price? Is it a time and materials contract, or is it a hybrid of the two? Now, what do we mean by that? I think most people will understand what a fixed price contract is. I'm going to replace your fence for $2,500, right? Guaranteed. Time and materials. I'm going to fix your fence. The cost per foot of lumber is going to be X, and the cost of my labor is going to be $45 per hour plus tax, right? The first one, the fixed price, obviously gives you the maximum protection because they've got to do all the work for a set price. The second one, time and materials, gives the contractor the maximum protection. However long it takes them to get that job done, whatever happens to the price of lumber, and we all saw it skyrocketed earlier this year, right? Everybody was in a COVID panic. We have to redo everything in our home right away, right? Lumber, doubled or tripled in price in a matter of a few months. And it has come down quite a bit, but it's still significantly more expensive than it was some years back. And then you've got a hybrid of the two, right? A hybrid of the two is really a compromise position between the two extremes. You've typically got a fixed price component, and then you'll have a component that is time and materials based. Why do you use a hybrid model? A lot of times contractors simply refuse to do a fully fixed price contract. And sometimes that refusal is actually pretty reasonable, right? So let's say that the project in question is to replace a bunch of parts of your building envelope. You've got a wood frame building. The scope of work includes rot replacement because you probably had some water come in over the years. Well, a contractor would be crazy to do rot replacement on a fixed price deal because until they open up the walls, they have no idea how bad it is, right? So in those sorts of cases, you often see a hybrid where there'll be a fixed price for the work, but then there'll be time and materials for things like rot replacement because we don't really know how bad it's going to be until we open up the walls. So hybrids can be a very good model. You want to have a contract that addresses unexpected conditions, such as a rot replacement, like I talked about. You want to have a contract that addresses how you deal with problems when things go wrong. Who bears the risk? Is it the strata or is it the contractor? Obviously, as a strata, you want all the risk transferred to them and they want all the risk transferred to you. So it's usually a bit of a compromise between the two, right? If things go wrong, how are you going to resolve your issues? Are you going to rush off to court and lawyer up? Are you going to have a mandatory mediation process? Are you going to have arbitration? All of these things can have a significant impact on the ease and the cost of resolving disputes. Is there going to be an indemnity? What happens if they screw something up and a big flood happens? Is there going to be a warranty? They finish the job 6 months later, you find out they messed up a couple of things. Can you bring them back under the same contract and say, we don't have to pay you more money, but you got to step in and fix this? So all of those components are really, really critical to have within a written contract. And it's the central reason why you don't want to just simply sign a quote without any other terms and conditions. Now, in terms of the contracting basics, obviously you've got parties to a contract, you've got the scope of work. That's going to include a description of the work. There may be drawings and specifications prepared by your architect and engineer. You may have manufacturer's specifications and industry standards. All of those things are really, really critical because as with anything in life, there are good ways to do things, there are okay ways to do things, and there are really terrible ways to do things, right? So having specificity in the scope of work, ensuring that you've got a reliable system being put in place or a reliable methodology of construction, it's really critical to ensuring that you get what you paid for and that you don't have problems going forward. There's nothing quite like that feeling when a strata corporation comes to you. They've hired a contractor to do a bunch of work, and the contractor has screwed it up so badly that the strata is now looking at having to redo that work or a significant component of it. It's a really, really awful feeling for strata corporations to have. And as a lawyer that works for strata corporations, I have a tremendous amount of sympathy for owners in those circumstances. You've obviously going to want to have a contract that sets out pricing, and we've talked about the different models a few minutes ago, so I won't go through those. You're going to want to have a contract that addresses whether or not permits are required. Nothing worse than having a bunch of work done without a permit, only to find out that you need a permit and the municipality has now stepped in and told you that you're in big trouble. So getting your permits cleared up at the front end is really critical. You're going to want to look at site supervision. Who's overseeing all of this work? Is it the contractor that's overseeing themselves? Is there an outside engineer or an architect that's supervising? How are you going to manage that process? And then, of course, you've got the qualifications of the workers and the trades that are on site actually doing the work, right? As with anything in life, there are good and bad contractors, just like there are good and bad engineers and good and bad lawyers and everything else, right? So you want to ensure that you've got quality people in place that are qualified to do the job. And that is particularly important when you are dealing with large projects or projects that come with an inherent degree of risk to them, i.e. if something goes wrong, it's really going to cause a problem, right? So those are all things you want to set out in your contractual provisions. You're going to want to have a construction schedule. You don't want to get into a contract without a schedule and find out that the contractor has 12 other jobs on the go and you thought it would take 6 months and now it's going to take 2 years and 6 months to get the job done. Nobody wants to see that happen. Your owners are going to be very upset with the situation. You're going to be living in chaos for a lot longer. So having a detailed construction schedule is really critical. Site cleanup is also critical, and you don't want them walking off and leaving a big mess. Hours of work, right? If you don't have a set schedule in terms of hours of work and days of the week when they can work, and your contractors are on site at all hours of the day, you're going to get a lot of angry calls from owners. You may be getting contacted by the local government if there are noise complaints from neighboring buildings. All sorts of bad things can arise in that case. Holdbacks are another critical one. I won't get into all the details of holdbacks. Suffice to say that under the Builders Lien Act, there is a requirement that for contracts that are $100,000 or greater, any homeowner, whether a strata or otherwise, is required to hold back money from payment to the contractor. And that money is being held back to ensure that if liens are filed at a later point within the project or following completion of the project, there is some money available to ensure that those liens get paid off. So this is a statutory requirement under the Builders Lien Act. Indemnities and warranties are also really critical, as we talked about those earlier, as is liability insurance, which we also talked about earlier. WorkSafe BC status, critical one, right? And WCB is sort of an adjacent component to that, right? All of us who've been following the news know that in recent months, we've had some really, really horrible workplace accidents and deaths that have arisen. I point to the example of that crane collapse in Kelowna some months ago, and the more recent crane collapse in North Vancouver at that movie theater that was being dismantled. Ensuring that you've got WCB, ensuring that you've got WorkSafe BC status all lined up, really, really critical, right? You don't want to get into a situation where not only are you dealing with some sort of an accident or a tragedy, but you don't have the support mechanisms in place to deal with that properly. You're going to want to ensure that the contract, particularly if it's a more significant one, includes things like maintenance manuals and as-built drawings, right? You don't want to go and replace all of your plumbing in the building only to find out that the contractor isn't required to give you a set of as-built drawings showing you where all those new pipes are that they installed, right? Then in 5 years, when you're doing renovation work, you open up the walls and, oh, there's no pipe there. Where is it? Where did they put it? We have no idea, right? So getting as-built drawings, getting maintenance manuals, critical to allow you to manage those new assets going forward. Tendering. I said I would return to this one at the beginning, and we're going to do that now. I'm not going to get into all of the details of tendering law because it is a bit of a minefield. But let me start by saying that tendering is essentially a process whereby a professional, typically an architect or an engineer, will prepare a formal tender package, and they will solicit bids from prospective contractors on behalf of a strata corporation. So a tendering package is going to include a detailed set of instructions to the bidders. It will include drawings, specifications, material standards, installation standards from manufacturers, all of this sort of stuff, all put together in a neat and tidy 50, 100, 200-page document, which is very, very dense. And unless you're in the industry, a lot of it will make your eyes gloss over. But the architect or the engineer will prepare those documents. They will solicit bids and then ultimately assist you in assessing the bids once received. Tendering, as I indicated earlier, is much more frequently used for large projects, and it can result in significant savings, but it also comes with certain legal risks. And I note those at the bottom. You can have things such as disgruntled bidders bringing a claim against the strata corporation, such as for failure to advise of a material clause, failure to follow the tendering procedures, these sorts of things. Strata corporations have been sued for tendering jobs gone wrong. There were a couple of cases some years ago that dealt with this. One was a case called Silex Restoration and Strataplan VR 2096. The other was Cambridge Plumbing and Strataplan VR 1642. Both of those were cases that ultimately went to the BC Supreme Court. Ultimately, in both of those cases, the strata was successful at defeating the claims. But of course, they were successful, but they still had to spend a bunch of money hiring lawyers to challenge these claims, right? Why were those strata corporations successful? Well, they had things within their tendering package that helped to give the strata greater protection. They had a privilege clause that allowed the strata corporation to not necessarily accept the lowest bidder. They had a discretion clause, which is essentially a clause that allowed the strata corporation to accept a bid that was not 100% compliant with the bid instructions. And they also had other sorts of clauses, such as a financing clause. There's no contract until our owners approve spending this money, right? And finally, they had things like a damages clause. If you don't get the contract and you decide to sue us, you and I both agree in advance that your damages are limited to the cost for you to prepare that bid package, not the loss of profits you would have made if you had done this entire job for us. So these are the sorts of clauses that can and should be added to tendering documents to help give your counsel and your owners greater flexibility in making decisions, and ultimately to protect them in the event of a liability claim. Conflicts of interest, this is another really important one. Under the Strata Property Act, Strata Council members have an obligation to be mindful of any direct or indirect conflicts of interest. Those can arise in situations where a council member or a strata corporation is dealing with a proposed contract, and the council member has a direct or indirect relationship to the contractor in question that is proposing to do business with the strata corporation. But they can also arise in any other circumstance where the decision at hand is one that could create either a direct or an indirect interest for the particular council member. When those situations arise, council members have an obligation to recuse themselves from any discussion and any vote on those matters. They've got an obligation to disclose that conflict to their fellow council members and basically to extricate themselves from that process completely. If they don't do that, it's opening up the strata corporation to legal claims by disgruntled owners. It's opening up the council member to potential claims by disgruntled owners. The strata corporation's insurance will probably not cover you in those circumstances. I would frankly be shocked if you found a policy that did, because those are the easy ones for insurers to exclude. And, as I said a moment ago, typically it's very difficult for claimants to ever bring claims against strata council members personally when they are fulfilling the strata corporation's business. But if a council member is engaging in conduct where there is a conflict of interest, and if it can be shown that they received some direct or indirect financial benefit, there's some very good arguments there that a claimant could pierce the corporate veil of the strata corporation and sue the council member personally. So you need to be very, very cautious if anybody that you know or anybody that you're related to is looking to try to do business with your strata corporation. So we've got a couple of examples we're going to get into now. I'll move through them fairly quickly because I do want to leave some time for questions at the end. We've got 5 different scenarios there that we've fleshed out, and we'll start with the gutter cleaning example. So got a gutter cleaning contract. It's a great one to start with. What could possibly go wrong? Accident or injury? I can tell you, I once tried to clean my own gutters. Never again. I'm not getting up on that ladder. It's way too high. That's a really significant one when you're dealing with gutter cleaning. Damage to property and roofing. Somebody's up there cleaning, holds on too tight to the gutter and busts it off, damages your building, damages the roofing. Failure to complete the scope of work. You hire somebody to do some work, you pay them all this money up front and they disappear halfway through the job. The frequency of cleaning, how often are they going to be up there to clean those gutters, right? And what times of the year, right? Are they going to be doing it in the summer when all the trees are still covered in leaves, or are they going to be doing it in the fall after all those leaves have clogged up your gutters? And then of course, cost, that's a really critical one there.
So, a number of the questions relate to this set with respects to townhouse developments. Oftentimes, and we see this routinely, where strata corporations have adopted bylaws or rules that require owners to actually maintain things like their gutters or their windows on the exterior of their townhouses. But it's common property, so the answer is no, you can't do it. But the other side of it is the amount of liability that's being imposed with any type of volunteer work that may result in injury, because WorkSafe and WCB are the same thing. WorkSafe does not cover volunteers, does not cover strata council members, those people who are living within the complex that are doing work within their own complex. And I think that kind of transcends this to gutter cleaning, because people, stratas are often looking, how can we get this done quickly, cheaply, and not worried about it? And frequently will retain companies that, if you go online and check, probably don't have WorkSafe coverage. And that's a big problem.
Yeah, absolutely. It's a significant issue. And, because of the risk of injury or other problems, if you've got owners that they're not going to do that work because they're not comfortable with it, then that work gets ignored. You're going to have the potential for backups and water damage into your building, clogging of your drains, these sorts of things. It's a huge issue. And like the reality is, when you get into things like gutter cleaning, we've all got different risk tolerances for getting up on a ladder. You know where mine is in terms of my comments a few minutes ago. We've all got different skill levels and health levels, right? I've dealt with stratas over the years where they've got, somebody on site who's, 60, 70, 80 years old, and they're up on a ladder cleaning off gutters. And it makes me cringe, because I just know at some point there's a real risk of injury there. And, God knows what's going to happen. So these are classic examples where, yes, you could make owners responsible, but in the end of the day, it's just a terrible idea. You don't want to go anywhere near that. So yeah, it really is something you need to be very cautious about.
But you really can't if it's common property anyhow.
No, you
Right?
can't, right?
Right.
Absolutely.
So and then how does that affect your liability on your insurance policies and everything else associated with it? So yeah, just a bad idea. And people forgetting the whole point we moved into a strata community was so we could collectively buy the power of somebody else to do the work for us.
Yeah. Yeah. And just further to Tony's comment, the Strata Property Act has this little provision about stratas making owners responsible for common property repairs if set out in the regulations. The BC government has never passed a regulation allowing this. So effectively, even though there's a reference to this in the Strata Property Act, there's no regulation that actually says you can make an owner responsible for this. So it's just simply a no-go right now. And hopefully it stays that way, frankly. Next one, HVAC service contracts. What could possibly go wrong? Well, obviously accident and injury, that's a common one. Damage to property, failure to complete the work. Those are common to many of these situations, so I won't go into them again. Performance, this is a critical one here, right? How often are the HVAC systems actually going to be cleaned? Is it monthly, quarterly, yearly, biannually, whatever, right? You need to ensure that the level of cleaning is sufficient for the building that you have, for the complexity of the system you're dealing with, for the age of the building. If you don't do that, you've got all sorts of increased risks for fire and other sorts of related problems to your system. What materials are included? Are they providing, all of the HVAC related materials, the ductwork, et cetera, or are you paying for that separately? That's a critical one. You want a description of the services that are being performed. That's obviously critical. You don't want them fixing some of the HVAC system and not others, right? Or if they're not going to do some of it, you want to know what those are so that you can arrange for somebody else to do that work. Reporting and billing. How do you actually confirm that the work has been completed, right? I mean, we've all brought people out to work on our homes and whatever at some point, and like, unless you're a professional and know what to look for, you'll have no idea if they've done the work, right? Or sometimes the work is covered up, like it's all buried within the walls or the ceiling. And so it's a trust system in the end of the day. So you do need to be really clear on those requirements and expectations before you enter into a contract. Ooh, elevator service contracts. They're one of my favorites.
Yeah.
I hope nobody works for the elevator companies. Elevator service contracts are some of the worst, most draconian pieces of contract language that you will ever come across. I talked to a lawyer once who works in-house at one of the elevator companies, and she rather candidly told me, we make no money on installing elevators. We make all our money on servicing the elevators, right? So bear that in mind when you sign an elevator service contract. Obviously at the top, we talk about some of the common problems. As you move down that list, what materials and services are included? That's a critical one for elevator servicing contracts. Those pieces of equipment are really, really expensive. And, they're constantly coming back to you and saying, oh, this, you need to get a new this and a new that. And you're like, okay, I don't know how to operate an elevator. Sure, that sounds good. Where do I sign, right? You want to be really clear on what materials and services are included because it can add up really, really quickly. Reporting and billing is another critical one. The details of emergency response protocols, like if they've got to come out because the elevator stops working on a Saturday night, how much is it going to cost you on a Saturday night versus on a Tuesday morning? That kind of stuff, right? After hours calls, costs, and rates ties into the same thing. They can add up very, very quickly. Limitations on servicing or proprietary materials. They've all, if you've got a company that installed your elevator and now they're servicing it, there's probably a contract in your maintenance manual that basically says, if you ever use any piece of equipment that isn't supplied by us, everything's off the table. You're in breach of the contract, your warranty's expired, no rights for you. So you need to be aware of those provisions within there. Having a detailed scope of work is really critical. I make the point at the end, punitive termination clauses. We don't think about this one a lot, but almost every single elevator service contract I've ever seen, and indeed, contracts for garbage removal, recycling, etc., they have very, very draconian language that makes it nearly impossible for you to get out of the contract. Or if you do, it'll have a clause that will say something like, if you terminate the contract, we get the right to sue you for all of our lost profits until the end of this term of the contract. So if you terminate them in year 2 of a 5-year contract, you can probably expect to see a letter from the lawyer that says, hey, here's our bill for the next 3 years of service, right? So you need to be really aware of the sneaky language that a lot of these companies put into these contracts. Obviously, the best way to try to deal with those is at the front end. We'd really like to do business with you, but you got to change that clause. You always want to be mindful of that because in the end of the day, it can make it very, very hard to get out of those contracts. And if you do get out, it's usually for a lot more money than you would have liked to have paid to get out.
Just from the perspective of my own building in the last 3 years, we renegotiated our elevator contract, much better results. And most of these conditions had been renegotiated. But most important, we itemized all of the components that were part of the service contract that were the responsibility of what we were paying on a monthly basis. So the ropes, for example, which are the cables that the elevators run through, were required to be replaced once every 5 years at the greatest. And because now they're so wound so tight with smaller pulleys, their life expectancy is so much shorter. This is a significant expense. And it's interesting in looking back over the building over 10, 15 years, it had been done, but it was an additional surcharge and no one reviewed the contracts to discover it was actually part of the contract. Mm-hmm. And so not only do you need to have a very detailed contract, but if possible, and we've been very successful with an elevator consulting engineer who reviews the contract closely for us and understands the language of what is actually expected in the contract.
Yeah, that's a really good piece of advice. It can get super, super technical. Last example we have here, major construction projects, and I've in brackets put a couple of different examples. Obviously, for major construction projects, you want an independent consultant or technician to act on your behalf and protect your interests. Their role is going to include things like setting the scope of work, creating specifications and overseeing the bidding process, supervising construction to confirm that the services and products meet the design and installation specs. That's a really critical one. Like if you're doing a plumbing redo, repiping your whole building, nobody on council, I would suggest, is going to have the time nor necessarily the expertise to monitor that work and ensure it's actually done properly, right? And you don't want to find out it was done improperly after the fact when water starts flooding out of somebody's walls or ceiling. And we want to make sure, obviously, that that project meets the local government permitting requirements. You're going to want to have a detailed payment schedule, and you're going to want to have that consultant assist you in monitoring the payment schedule and helping you to approve payments to make sure you're not paying too much in advance before the work is actually done. And then, of course, they've got to sign off on substantial completion. This sort of work is really, really critical when you're dealing with big dollar value or high risk contracts. You just don't want to get into a situation where you're trying to cut corners to try to save some money, and then in the end of the day, you find out that a lot of that work that you paid for has been wasted work and is going to need to get redone or repaired. Other benefits of the professionals: predictable costs and competitive rates for services. They can help you to resolve owner-contractor disputes, and those are really frequent on large contracts, right? Like if you give that example earlier, we talked about fixed pricing versus time and materials when it comes to rot repairs, right? Having a professional there to look out for your interests, to act as a neutral to try to resolve these issues in the event of a dispute, will give both sides greater clarity as to what is part of the fixed price and what's not. and how much it ought to cost to do that work. So having them there, yes, it's an extra cost, but it will hopefully help to reduce the chances for conflict and keep you out of the courts as much as possible. Third-party inspections are really, really critical to ensure that the work is being done. I mean, at the end of the day, contractors there to do the work for the most money they can, for the least cost they can. And you want to have a third-party inspector to be there to ensure that you get the most value for the money you've paid and that there is a minimization of future problems. You want to ensure or have that consultant there to help ensure that there are no defects within the project, to ensure that those defects get corrected prior to construction. You're going to want to ensure that the contract itself contains some level of guarantees and warranties to protect you in the event that problems are discovered after the fact. And then last point I make here, and this is really in terms of having professionals like architects or engineers involved. It's a bit of a jaded comment, but I think it's important to make, right? Like in the end of the day, you know, none of us want to get into a project that goes wrong, but if it does, you want to have as many people as possible to blame so that you can try to recoup those losses, right? So if you've got a big project, whether it's a piping replacement, building envelope repair, roof replacement, whatever, having both a contract with a contractor and having them be insured and a contract with an engineer or architect and having them be insured allows you to ensure that there is more insurance money at the table, more potential blame to go around, and hopefully a greater recovery at the end of that dispute, right? Because in the end of the day, having those people there allows, you know, you get into court, the contractor is going to say, oh, it was a terrible design. And the engineer is going to say, no, it was a terrible construction. And you can go to the judge like, you know, in the end of the day, I don't really care, Your Honor, as long as one of these people has to pay me back for the losses we've suffered. So having those experts involved allows you to spread the blame around, spread the risk around, hopefully get more insurance money at the table and get to a resolution quicker. Questions?
So we're tight for time. It's 1 o'clock. But I have a few that are, I think, that are really relevant. Under a tendering process, what's the problem for a strata corporation? And I think you've already alluded to this on liability, but one of the challenges is when a strata council member discloses tendering prices. You know, like that's, and I'd like to say it never happens, but the number of complaints we get are a little terrifying.
Yeah, it can be problematic, right? Like the situation that you'll sometimes see is that people are far too willing to disclose confidential tendering info, confidential pricing info. The risk there is that can get back to another potential bidder. They may have an insider's sort of scoop on what the pricing is that they need to beat. And then, of course, the aggrieved contractor can file a complaint or bring a lawsuit against the strata corporation. So those are certainly some risks that you need to be mindful of. We need to always ensure that we protect the confidentiality of the tendering process to minimize the risk of complaints. But as I also alluded to earlier, you also want to have language within that contract that allows you to not necessarily accept the lowest bid, right? And this is a really critical one because you know, if you have an open tendering process, for example, you might get 10 bids in on a project. And you're looking at those bids and one contractor comes in and they're like 20% less than the next lowest bidder. And your first inclination might be, oh, let's go with this person because they're so cheap, right? Well, you start talking to your engineer and they're like, you know what, these guys are a real pain to work with. You know, that clause about time and materials for rot replacement, they run with that clause throughout the whole project and they're going to be trying to nickel and dime you on every single extra they can, and it's going to turn into a nightmare, and you may end up paying more than the second lowest person, right? So that kind of insider knowledge, that experience that the engineers and architects have in terms of knowing who are the problematic versus the easier to deal with contractors, you're going to want to take those things into consideration when you select who to go with. And you're going to want to have a clause in your contract that says we don't have to go with the lowest bid. So those are really important things to protect yourself.
Super. And another question I think that relates back to WorkSafe, which comes down to the liability of the strata corporation, is the mechanics of how does a strata control that a contractor who's being hired by an owner doing, let's say they're doing kitchen renovations, ripping out the kitchen cabinets, the plumbing, how do they ensure in some capacity that that contractor is covered by WorkSafe and has insurance? Because the problem is if that contractor ends up with an injury or there ends up being environmental problems or other issues, ultimately the strata corporation is still potentially on the hook for this.
Yeah, no, that's a great question. And, you can never, you can never protect yourself 100% in these cases. And the reality is somebody can bring a bad claim, right? We can't, the court doesn't screen those claims out at the front end. But how can you protect yourself as a strata corporation? You want to obviously look at having bylaws that speak to this issue. You want to have a robust alteration bylaw that speaks to the requirements and the expectations of the strata corporation. You want to have very detailed and precise alteration agreements between strata corporations and owners that set out the expectations of the strata corporation, that make clear that the owner has the obligation to ensure that those sorts of coverages are in place. Strata corporations often enact bylaws that deal with things like indemnities from owners in the event of a claim. These are the types of situations where you could expand that indemnity language to cover situations where an owner has failed to ensure that the people on site have gotten proper coverage for those sorts of workplace injuries. So those things aren't necessarily going to prevent somebody, a third party, from suing you, because you don't have a contract with the contractor, right? But it will give you some recourse in the event that a claim is brought, and hopefully the language of the bylaws, the language of the alteration agreement is strong enough that owners will take those steps to get those assurances. You can go even further and say something like, we're simply not going to give approval until you provide us with proof that these coverages are in place. So there's a bunch of things that you can do to try to mitigate those risks.
Excellent, thank you. And one more, which I think is, you didn't kind of touch on, but it's a little bit of a hornet's nest of a question. The strata management companies frequently have clauses that charge a fee for any contracts over a certain amount, and that they will act as the project manager. So how does that role function when they're not actually project managers by qualification or by profession? But by doing that, doesn't that place the managers in the positions of having to manage and comply with WorkSafe requirements on major projects?
Yeah, it is. That one is quite a bit of a hornet's nest. I think if you look at it from the perspective of the management company, they're looking at it this going, well, there's going to be a lot of extra work for the managers here. We want to have some compensation above and beyond what we might normally be able to charge, right? So
right, yeah.
They're approaching this from a capacity standpoint and how much time this is going to occupy for the manager. On the other hand, like you said, Tony, the reality is, most people in those circumstances aren't necessarily going to be qualified to serve as project managers, just like I wouldn't, right? And so I think in the end of the day, if you're looking at those sorts of charges and those sorts of services, I think you need to be, we need to be very cautious in terms of having managers expand their services into areas that they're not necessarily qualified to provide. I think having that caution is a good thing from a manager's perspective, as well as from the strata corporation's perspective, right? In the end of the day, if there's a reasonable basis for charging an extra for additional work, that's fine, but that should not replace the need to have properly qualified professionals on site, like an architect or an engineer, to supervise what's going on, or to manage the construction process on a more day-to-day basis in terms of project coordination. I would view their role as being more of a facilitation type role, right? To ensuring communication happens when it needs to, contractors get in touch with owners to get access to units when they need to, these sorts of things. But as a manager, I'd be very cautious about treading into any areas where you're actually having to make decisions on how complete a project is or whether it was done properly, these sorts of things, because those things can create problems for your strata corporation if they're not done properly. And obviously it can create problems for you as the manager if things go wrong, and then you find yourself in a dispute with your strata corporation because you thought they were supervising the project and really you're mostly just facilitating. So the charges are the charges, but you need to be clear what the scope of work is and where it doesn't extend to.
That's super. I know people are end of their lunch hour, so we're gonna call it there, Sat. Thanks so much. That's just brilliant. Thanks to TELUS for sponsoring. BC Housing is our partner in research also. If you go to the CHOA website under BC Housing, you will find that there are an extensive number of guides that help with different research projects, operational components for buildings, instruction guides on risk management. There are a lot of great resources. I will spin back to the top of the page with Sat's name and his email address. And so if you have any additional questions, pop Sat an email. Donna will be distributing a copy of this to the people who participated, and you will also find this presentation posted on our YouTube channel. Please share it with your Strata Council members, your property managers, with everyone else. In 2 weeks, we were planning on having a session on WorkSafe, but because of the pressure and the changes with COVID and everything that's going to occur, we're going to do a session actually on how we're going to get through the next fall and through meetings and through vaccine cards and everything else on COVID in 2 weeks. So sign up for that and join us again in a few weeks. So thanks everyone again. Hope you all have a great day.